Hopefully my lords and my lady have got the letter that I referred to. I don't intend to take up time now.
Right.
It's a very short letter. It's halfway through the second page is the key bit that I was referring to. And it was sent in the run-up to the first trial.
Right. Thank you.
Now, my lords and my lady, I was just about to move on. We've been looking at dealing with the email addresses. And I was just about to move on to how that was dealt with at the remitted hearing. And what actually arose at that point in time was a point that the parties hadn't focused on before. And that was, what about employees outside the UK, but also outside the permitted territories, so outside US and Canada? Should the UK order require them not to use their email addresses, including the @merck.com suffix, when sending emails into the UK, obviously? And previously, the judge had allowed the US and Canada-based employees to use their Merck.com email addresses. And by the time we got to the remitted issues hearing, there was evidence filed directed to the costs of moving over to national email addresses. And in fact, another thing that had happened that my lord and my lady ought to note is that in fact the French court had already ordered a change for the French-based employees. And that is maybe perhaps why it came into focus. Should the injunction in fact bite only on UK-based employees, leaving the courts of other territories where employees were based, like France, to determine whether employees based there should change? And actually that's what the judge decided to do it just for the UK. And I'll show you the entire focus is on employees and their numbers and how costly it might be to move them over to an MSD email address. In fact, it is the monitoring after the change, not the initial change, which is the real point. And let me show you, if I may, that aspect of the remitted hearing judgment. So I'm in the supplementary core bundle tab 4, and can we pick it up at the foot of page 182? And I'm looking, please, at paragraph 84. But right at the bottom, it's the judge turning to the use of the Merck.com email addresses, which over the page, the judge says is a breach of contract, and says that the remedy must be fashioned to deal with it. And here he's addressing the issue of its use also being a trademark infringement. And he's addressing the fact that on appeal we had established that a given use might be use of a company name and trademark use, which in fact he'd overlooked in his first judgment. And in paragraph 85, he's addressing the issue of how one regards a use that could be regarded as a trade name also to be trademark use. And he draws attention to the parallel between the use of an email address by a US-based employee and use of a mark on a letter or business card sent from or presented by an employee in the US. And that's an analogy between individuals using domestic stationery or visiting cards in writing or visiting in the other territory. And I don't know whether my lords and my lady have picked up, that's specifically allowed for in the 1975 protocol, which, just for your notice, in tab 16 of the core bundle. And what we see is he distinguishes those instances from use of email addresses of the kind he identifies in paragraph 86, which he explains link Merck US as originator of products or services. And they're all these generic kind of email addresses. And of course this is addressing trademark infringement specifically, and he's saying they're a breach of contract too, as the judge said at the beginning of the passage, but he says they're also a trademark infringement. The point I'm making coming here is that these ones are the ones that create the link with goods, and moreover there's no discussion in the context of these of them being email addresses for employees. Contrast paragraph 85. And the idea that they're email addresses for employees just wasn't in anyone's mind in my submission, and that's for the simple reason is that are obviously not. They are ways to communicate to the company about topics indicated in the first half of the email address, and nobody would consider them an email address for any employee let alone go on and ask where in the world is that employee based. And when it came to framing the relief, my lords and my lady, you need to look at paragraph 120 onwards on page 191. In fact, we can pick it up at 121, where the judge refers to the use of different email addresses in Germany, which had always been the case. And you can see that the judge refers to personal email and the operation of mailboxes, where the domain may be a brand or product at the end of 121. So again, he's drawing the distinction between personal emails and what we are now calling generic email addresses. He calls them mailboxes. And the following debate is all about the costs and associated administrative work needed in changing the large number of personal emails. So you see in paragraph 122, it's not the change of domains as such that's the issue, something I foreshadowed just a minute ago, at least according to one of their witnesses. It's the administrative support required for testing and communicating with employees over the change. And you see the examples given in brackets here are over their health insurance and their pension administration. And the point, as I understand it, was the issue that things like that perhaps being overlooked if you just changed email addresses, and then important communications with employees, particularly as regards their status as employees, going astray. And there's more of the same thing right through page 192, including a reference to France and the change required there. And this culminates at the foot of the page, para 127, where the judge says he's content that there should also be a change for employees in the UK. He says towards the foot of the page it was never intended to cover employees based in the permitted territories, refers to the fact that his previous order had a carve-out for employees based there, so US and Canada. And right at the foot of the page he says, what's been thrown into sharp focus this time was what about employees not in the UK and not in the permitted territories? So over the page, he asks the question, should the order as a practical effect require a change of email address for them? And he answers this no in the next paragraph, 128. Says he didn't have the evidence to enable this to be considered properly. And we see he also was concerned about the extraterritorial effect of his order. At the end of this paragraph, he explains that he's going to carve out email addresses ending in @merck.com for employees based outside the UK. And he also explains he's including the words in the ordinary course of business because he didn't want the defendant's well-demonstrated tendency to push the boundaries to lead to it to relocate UK-based operations or functions. Say, the example he gives is to the Netherlands, so they can be conducted using Merck.com email addresses. What the judge has in mind here is not the mailbox email addresses, because no one's thinking in terms of email addresses for employees covering those at all. But the sentiment he's expressing does shed some light on this. He was even worried that they would set things up so as to have non-UK employees, say the Dutch here, targeting the UK with @merck.com emails, and he didn't want to allow that. Now, my learned friend points to this passage of paragraphs up to paragraph 128 in their skeleton at para 90, and they particularly pick out 127. And what they do here is pick out the wording about not intending to have US-based employees change their email addresses. So those last 4 lines underlined and emboldened on page 44 of the bundle in their skeleton. But that, in my submission, is just not engaging with the point. It's referring to use of Merck.com email addresses for its own employees within their territory. It's simply not addressing email addresses that are not for employees at all. And my friend simply asserts, this is paragraph 91 of his skeleton, that the judge was wrong. The judge explained why he concluded subparagraph 4D didn't cover generic email addresses. This is actually in the judgment itself, 299 to 301, so you need pages 153 to 154. He explained in paragraph 299 that for such an email address, that such an email address is not an email address for an employee based outside the UK. It is, as I've said already, it's a generic email address provided for the purpose of contacting the company itself. And as the judge says, this is right at the foot of page 153, in this particular instance, it's not an email address for Mr. Redding in his capacity as an employee of Merck US. That was what he was considering in this particular instance. Rather, it was a generic email address which he was required to monitor. And as I've already alluded to, that's an important difference. Indeed, as I think I've already said, one would never know who's monitoring it, whether it be more than one person, and when those people change. What, for example, is the position if there's a team of 3? Is it enough if one of them is US based? Must it be all, the majority, or what? It just wasn't in anyone's contemplation that email addresses for employees would cover this kind of thing in my submission. So we say that the judge was quite right in his construction. This provision is limited to @merck.com email addresses for employees, and moreover those based outside the UK. And it does not extend to generic email addresses, not intended to be a communication to an employee at all. And certainly not introducing what we say would be an arbitrary distinction as to where those unnamed and unknown individuals happen to be based for what would probably be a short period of time for those monitoring that particular mailbox. So that's what we have to say on the second limb of ground 3. And I was going to move on to paragraph 4H unless my lords and my lady have anything at all on that one before I move on. So the third and final limb is the attack on the judge's construction of that last subparagraph. And that's the provision that allows inadvertent acts in breach not to be considered a breach if corrected within 7 days. The structure of that provision is obviously to catch something which, absent this subparagraph, would otherwise be a breach. That's the reference to acting in breach in the body of the text of the subparagraph. So it must be otherwise contrary to the order, a breach in substance, if you will, and liability for breach is avoided if 2 conditions are met. First, inadvertence, and second, correction within 7 days of notification. And what this does is provide my friends with a considerable benefit. But the issue for my lords and my lady is whether this simply applies to slip-ups in the sense of things they do they didn't intend to do, so perhaps the wrong document being uploaded to a website due to a muddle over file names, or a document being changed to make all references to Merck references to MSD but one being missed, that kind of thing. Or does it extend to quite deliberate acts undertaken pursuant to a deliberate policy or a deliberate decision, but in the mistaken view that the order didn't prevent it? So the point of construction is this: does inadvertence encompass, i.e. extend to, a mistake about what the order permits and prohibits? And my friend rather shied away from saying it was a point of construction in his oral submissions, although it seemed to be put squarely that way below and also in the skeleton. And I have to say, I found his oral submissions quite difficult to follow as to why he was shying away. It is obviously a point of construction, and as I say, argued below as such, and indeed in the party skeletons. And I suspect my friend shied away from that because if the construction contended for by him, at least in his skeleton and before the judge, is right, it has some pretty startling consequences. And let me identify them for you. First, it renders the injunctions not to act in contravention of a contract or infringement of a trademark, those underlying unlawful acts that are strict liability and injunctions to comply are also strict liability, it renders them not strict liability at all. They become transformed so that it's only a breach to knowingly act contrary to the prohibition. You know that you're deliberately doing, that you deliberately do something that you know is in breach of the order, and indeed is a trademark infringement or contrary to the contractual obligation. And that, as a starting position, is quite a remarkable position in my submission. It's also, and this is a knock-on effect of this, to a very significant degree requires my clients to be monitoring and policing compliance with them. By them, sorry. It's all the more striking when you consider the history of this matter, of their constant and deliberate pushing at boundaries, that they decide for themselves what they can do, they can adopt a particular way of doing things. They then have immunity unless and until my clients discover it and complain. So the essence of the fight between us is whether that paragraph 4H exception on its proper construction means acting in a way that's not desired or intended, or whether it actually extends to doing things that are quite deliberate but just in the mistaken understanding as to whether or not it was permitted.
Well, the short point is that that is not the natural meaning of the word inadvertent.
Indeed. The short and perhaps the most powerful point, and I make that submission. There are a couple of other points that I do have to touch on, though, but not in any way to detract from my confidence in that submission. Before I do get into the debate, I want to deal with a point which my friend floated. He suggested that the judge decided some of the instances on burden of proof, having looked at how the burden might arise on the structure of this exception and who has to raise the issue. It's just not right in my submission to suggest that the judge decided any of these instances on burden of proof. My friend says we have the burden on any exception to an order. And my submission as a matter of construction is it depends on its nature. And the context, particularly important in this context, is the fact that nobody but my friends would know whether they would suggest it was inadvertent. And nobody could know if they say they changed in time to meet the time limit. And there's absolutely nothing exceptional in construing a provision like this as requiring them to raise it. Of course, after that, burdens can shift. But as interesting as all of that is, none of the instances were decided by the judge on a burden of proof point. My friend raised the defence in the cases where it arose, and his complaint is the judge rejected it because of the nature of what they said they were relying upon as to inadvertence. And there were cases where what they relied upon was clearly not inadvertence in the natural meaning, but that it was just a mistake as to whether they were allowed to do it. And that is the real dispute on paragraph 4H. It's not this burden of proof point. And the judge dealt with this point of construction at paragraph 127 onwards. And he correctly identified the real dispute on this on construction related to the word inadvertent. And that's paragraph 129, where he sets out our contention, which is followed in paragraph 130 by MSD's position. As he sets out there, my learned friend's position is that an act can be quite deliberate and still be both an error and one that's committed inadvertently. And we see the judge correctly identified the consequence of this argument in paragraph 131, at the top of page 115. And the argument that was being put forward before the judge was supported by my learned friend by reference to a case on electoral law, which was repeated in my friend's skeleton, but it's the Finch case, but it's not been included in the authorities bundle. Anyway, the judge dealt with it correctly in my submission and dismissed it through to paragraphs 1, 3, 4. My lords and my lady haven't been troubled with it again. And at paragraph 135, the judge explains something he has already referred to, that the subpara starts from the position that there must have been a breach and then deems relevant conduct not to be. Something that my friend jibs at, and I don't really understand why. He then moves on at para 136 to note that MSD's contention would operate so that almost every circumstance would be covered. As the judge said, there would be almost no circumstance in which the subparagraph will not operate. And he goes on and makes the obvious point, this is in the sentence bridging the page over to the top of page 116. It would operate in all cases, save for where a defendant acts in deliberate breach of paragraph 2 and or 3. And that echoes a practical point I made earlier. It would be highly unusual. And as the judge says, this involves a contumacious breach, which would be surprising conduct for a company like MSD to engage in.
But you get there much simpler, Mr Spack. Just look at the clause on page 228. The defendants inadvertently to act in breach. The word inadvertently qualifies act. It doesn't qualify breach.
I make that submission.
It's an inadvertent act, which is a breach of contract, and that is reinforced by the fact that it says inadvertent error. I can't see how you can read it any other way.
Well,
again, looking at it very simplistically as a matter of basic English language.
I agree with my lady. I agree, and I mean, I'm tempted.
Well, it's also the point that the concept of notification
Yes.
supports my lady's plain reading.
Exactly.
Because the point is that you're notifying them of something they are inadvertent.
Yeah.
Sure.
And it doesn't really work for notifying them of the fact that they've misunderstood.
Exactly, because then when do they find out? Because it's not just notifying; they could find out in other ways in the order. And this is something that actually vexed me a couple of days ago. And I think the point that my lord's putting to me is that if it covers just a different belief, and we tell them, are they then notified?
No, because just to pick up my lord's point, they would say, well, we don't think we're in breach. You would say, we think you are, and you'd be back in front of the court having an argument about whether they were or not.
Well, indeed.
So it would be unworkable.
But when does the time limit start to run?
Exactly. Well, it would be 7 days after the court order.
Well, but they don't. That's not their case, you see, and that's why I think the point that my lord's putting to me is absolutely right. It doesn't work on his construction because they want to say, oh, as long as you tell us there's a complaint, the 7 days runs from them. But it just doesn't work on their construction of inadvertent. I agree with you. I agree with you. I wonder whether I should. Yeah, I'm going to move to ground 4, unless you have anything else that you want me to cover on that. Ground 4 is short and sweet as well. My friend didn't actually didn't say anything orally about it at all. It's different to ground 1 in that the complaint here is about the fact that the judge didn't also give a negative declaration, even though they didn't ask for one. But what the argument is that the judge ought to, in fact it's more than that, the judge was appealably wrong, so it must be put in the sense of that it's not something a reasonable judge could have done in his discretion, must be put that way. And the argument is that the judge should have included in the declaration a negative declaration as to the instances where my clients failed. And my submission is it's obviously within the discretion of the judge to do what he did, and in fact he had a jolly good reason to do that, because if you start getting into negative declarations, you have to start thinking about why they might have failed. And let me just give you an example. You would get into a right pickle with an instance.
Sorry, just before we get into that point, you said it wasn't asked for, but I had understood from what was said in the appellant's skeleton argument that it had been asked for.
Sorry, I
it
meant
may be that was
no application.
I
I'm
was
sorry, I meant no application for negative declaration.
Oh, I see.
There was an argument at the form of order.
Right. So at that stage, it was asked.
Yeah,
for.
yeah, definitely. If I gave the impression that it wasn't even asked for at the form of order hearing, that wasn't what I meant.
Well, they could have counterclaimed.
That's what I meant. Yeah, they didn't. There was no application for a negative declaration. That was the point I was trying to convey, and I apologise if I put it too loosely.
That's helpful clarification, Dave.
And the point that I was just going to give as an illustration as to the confusion that you would get into with the declaratory, the negative declaratory relief where we'd failed, the judge identified is that you need to know why. And an obvious example, which would be really troublesome, would be one where we'd actually established that the act that we were complaining about was prohibited, but we'd failed because of the paragraph 4H exception. You wouldn't want people thinking, even employees in MSD thinking, or anybody thinking, that the effect of the declaration that allegation in row whatever it might be, having failed, meant that you could do what was the subject of that. And so, I mean, my friend was right not to push this orally, because the idea that it wasn't open to the judge to limit the declaration to those which had been found as established breaches for the reasons that he gave, in my submission, he doesn't even begin to identify what the error of principle is. There's no real attempt in the skeleton, and he didn't say anything orally, that begins to try and grapple with that difficulty. So,
well, again, the simple point seems to me to be that there was no claim for this relief. So how can a judge be criticised for not granting relief which wasn't claimed?
Indeed, that's another simple and comprehensive answer. I totally agree. So I've got to the end of everything that I needed to say, unless my lords or my lady have anything that you want.
No, thank you very much. Mr. Hobbs, any reply? Or Mr. Hollingworth, indeed.
There is a reply. Can you just give me a second or so to sort my papers out? It's gone a bit quicker than I thought it was going to go. Right. So, the first thing I wish to remind you of, if I may, is that every single ground on which I've appealed is one for which I have expressed permission from the judge below. And those grounds explicitly include matters which raise dimensions of fact. I'm as aware as anybody of the approach of the Court of Appeal towards, what should I say? It's the Fahey and Shabani point, it's the island hopping. We're all very familiar with that. But the judge himself gave me permission to appeal on grounds which involved that. Do you mind, please, if I show you, just to recapitulate on them, what the grounds are for which I've actually got permission? The reason I say that is that my learned friend has, at different points, said to you, well, it boils down to this, and there's a 1 strand and there's a 2 strand. In our skeleton of argument, we were meticulous to locate the paragraphs of our skeleton in relation to the grounds of appeal. So if you have the C bundle, the core bundle, page 15, every one of these was set out in writing to the judge in advance of the hearing at which he gave permission. And I haven't dropped any of these, and to the best of my ability, I have pursued them before this court. Now, I'm going to come back, of course, to number 1, which is itemised in subparas 1 to 5. I'm going to come back to that in a moment. But if you look at paragraph 2, at the bottom of that page, failing to recognise the unchallenged evidence. This is the judge giving me permission to argue relative to his judgment that he hadn't recognised the unchallenged evidence in the way that we complain of here. I'm not, as it were, embarking upon an exercise which is impermissible. I'm doing what the order is permitting me to do. Whether the court is satisfied in due course that I've shown a basis for it is another question altogether. Now, we have itemised down there, and I have addressed you, it's in the skeleton, but I have addressed you in relation to all of those matters in relation to targeting, the internet, and how targeting applies both in relation to paragraph 3 of the order and in relation to paragraph 4 of the order. Then in paragraph 3, I've set up the point on systematic interpretation of the order and so on, and I've identified the grounds, each one of which I have argued in my skeleton and I presented in argument. The fate of those arguments will shortly be entirely in the court's hands.
Nobody could accuse you, Mr Hobbs, of being anything other than comprehensive.
I take it as a compliment, my lady.
It was intended as such.
Thank you.
It's also the case that every ground of appeal we ever look at here, with very limited exceptions, is a ground for which permission has been granted.
Oh.
By someone.
By someone, yes. But the point I'm making is the judge himself, who had delivered a 500-plus paragraph judgment, is accepting that there is arguability, put it no higher than that, to the required standard in these matters which bring in factual dimensions. Now, where it goes from there, I've crossed the threshold with the judge, is my point, and how someone looking at it, a single Lord Justice in the Court of Appeal looking at it might have approached it, is another question again. I'm not going to labour this too much, but I did want you to understand, and my lady has indicated that the court is cognizant of this. We are focused on the grounds that here, and they do have factual dimensions to them. Now, may I go back to ground 1? The point here is this. I set out to establish, via my skeleton, in the paragraph which I cited that brought in the Supreme Court authority, and by my citation of Tesla to your lordships, that there is a requirement, or there certainly should be a requirement, in the law of declaratory relief for the existence of an applicable legal standard. The whole of my submissions on the first part of the case were directed to what I'm calling the legal standard point. Now, step back for a moment. They, by their drafting of the declaratory relief, define, in my case, in my submission, the legal standard. If they had, they haven't, but I'm hypothesizing, if they had asked for a declaration that my clients had breached Section 1.1 of the Theft Act 1968, or whatever the current incarnation of it is, that declaration, by the way it was framed for adjudication, would bring in all the parameters of the legal standard applicable to a determination of that issue. And the same happened, of course, in the Amstrad case, where I won all the civil arguments before the Court of Appeal, but the Court of Appeal declined relief because at one point during the hearing, it's scorched on my memory, Mr Mumby, for he it then was, handed to Mr Kentridge, for he it then was, a reference to Archbold and the crime of incitement, and Lord Justice Lawton sent the usher to the Lord Chief Justice's court next door to get the road traffic reports. And on the basis of the one case about the criminal law of incitement, the Court of Appeal declined to grant declaratory relief because it carried with it the possibility that it might cut across a prosecution for an offence under Section 21 of the Copyright Act 1956, even though their lordships were clear that it was a remote possibility. Now, they set the legal standard for the adjudication by the nature of the declaration they seek. The judge himself refers to this particular point in paragraph 47 of his judgment. So in the core bundle behind tab 5, you'll find paragraph 47 at the bottom of page 91 and up to the top of page 92. I had already raised this point at the case management conference before Mr Justice Mead. And as the judge entirely correctly records here, taking it across to the top of the page, if you can please read through with me to that, the judge, Mr Justice Mead, agreed there should be clarification in writing of what the claimant intended by its references to breaches of the order. The discussion ended with Mr Justice Mead assuming that the claimant would produce a revised and less charged form of words for the form of relief sought. And they didn't, and they haven't. And they have exercised their right to come and ask for an adjudication of breach. By my analogy, they're in the same position, metaphorically speaking, as if they'd asked for a declaration that I've breached Section 1.1 of the Theft Act or whatever it might be. Now, it's not irrelevant to notice that in the provisions of CPR 81, it's explicit in 81.4.2a that you have to state the nature of the alleged contempt, brackets, for example, breach of an order. It's given as a clear example of a contempt. Now, it doesn't cease to be an accusation of contempt via the breach complaint because they're bringing it via declaratory relief proceedings. It's not my case that they must bring it under CPR 81. I'm saying that the legal standard which is applicable if you make an assertion of breach which comes freighted with an allegation that you are in contempt of an order, in those circumstances the same standard should apply. You can't avoid them by coming under CPR 4020.
Did you submit to the judge below that he should be applying the criminal standard?
I said he shouldn't be doing it.
Well, quite. But you seem to be changing tack with respect here. I understood your submissions to be, quite clearly, that the way, if they wanted to accuse you of breach, they had to start contempt proceedings. And I understand that completely as a submission. But you're now saying they don't have to start contempt proceedings. They could bring a claim against you in the form that they have, but the judge would have to apply the criminal standard.
No, what I'm saying is, the way my lady's putting that back to me with respect is not quite the way I'm putting it. The way I'm putting it is, you can't escape the parameters of a contempt application with everything that involves for the safeguard of the defendant, by framing it as a claim for declaratory relief. And that's why I cited those cases in which judges have found that it's not appropriate to have a halfway house in the form of a declaration under CPR 4120. Because that's what it becomes.
So just to summarise, which are the cases which refer to halfway house?
There are two in particular. Can you forgive me for 1 second? It's
Mrs Justice Dias's case.
Mrs Justice Dias's case, which was, I think it's, yes, that's Investbank.
No.
And she repeated what had previously been said by Mr Justice Hildyard on this point when he refused to proceed with the declaration in these terms in the Bank St Petersburg, if I pronounce his name, Arkangelski correctly. Now, those are the halfway house cases, and it doesn't, just because you frame it as a declaration under CPR 40.20 doesn't relieve you of what is necessary to determine, according to the correct standard in point of law, the adjudication you're asking for. There was discussion at the end of yesterday and again this morning, on the question of whether they gave an undertaking or not. Well, they've given the assurance or the confirmation that they've given, and they've said that they'll turn it into an undertaking if that's requested. But that doesn't meet my point. The point is, as I sought to say yesterday, when I was up, the standard that is applicable is the one I'm saying for the protection of the defendant in these circumstances. You can't escape it by giving an undertaking not to invoke in circumstances where your adjudication is by its very nature bringing into play the factors that I've identified. All it's done...
For my benefit, and I'm being very slow here, Mr Hobbs. What is the standard you say they can't escape? Because that's what I'm having difficulty with.
Right. The standard is that when someone is accused of a breach of a court order, which is in terms actually, according to CPR 81, a contempt, that's what a breach of a court order is.
Well, no, it isn't, is it?
Yes.
No.
It has to be deliberate.
If you accuse someone of a breach of, and they did accuse me of doing it deliberately in the passages I showed you.
No, it's not coterminous, though, is it?
No, it has to be deliberate breach, or at least reckless.
Am I in CPR 81 or am I in 4020? This is a standard that you apply when there is an accusation of breach of a court order. I say, breach of a court order. It may be that in these exchanges that perhaps the members of the court are putting to me a more nuanced meaning of the expression breach. I have read this breach as meaning exactly the way it's used in CPR 81, and not least because they have said on the other side that they reserve the right in the event that there's a repetition of the acts that they've brought up for adjudication here to move for contempt. They have specifically
on the basis of future breach.
On the basis of future breach. But the platform for that will be the findings of breach which are made here. And that's why I keep using the expression platform, and that's why Mr Justice Hildyard used the expression a halfway house. Now, I am wondering whether I am transmitting and receiving on the same frequency as the court on the meaning of the word breach.
No, I think we all understand what's meant by breach, but the point my lord was putting to you is that for the purposes of CPR 81, although breach of a court order is one of the illustrations of the way in which you can be in contempt of court,
yes.
If it turns out that the breach is entirely innocent
yes.
And innocuous, you would not be in contempt.
I understand, but by then you've gone through the CPR 81 procedure, and in which the whole of the procedure is set up in a quasi-criminal fashion, and that's because ECR rules, in particular, I think it's ECR Article 6,
it's
requires...
because your liberty is at stake, or because you're liable to sequestration and all of those other penal...
And punishment,
yes.
Etc. But there's no doubt that under the existing rules, even though CPR 81 is a civil procedure, there's no doubt in the case law that it has to be approached as a quasi-criminal matter. Amongst other things, you have to set out your averments in much the same way as you would, I'll call it by analogy, an indictment. It
Yes.
isn't, but you have to. It has to be precise, it has to be put in specific counts. You give your evidence, and the defendant has a right to silence. There is absolutely no compulsion on a defendant to give evidence at all. And I've seen cases...
Since you've come back to that point,
yes.
let me ask you this question. Do you say you were deprived of the right of silence?
In circumstances where... Well, effectively, yes. Because in circumstances
And
where I'm
which
called
court
upon...
compelled you
No.
to serve and rely upon the witness statements you served?
How can I defend myself in a CPR 40.20? I'm sorry, I don't mean to ask my lord a question. I'm faced with a CPR 40.
You chose to serve evidence in answer.
I did.
Why is that depriving you of your right of silence?
Because the case that I was meeting was one of, this is not a contempt application, it's a CPR 40.20. And I have to meet the case that's coming against me at the same time as I'm objecting to the way in which it's being set up on the balance of probabilities, so a lower standard of proof, and all the other matters.
But you see, what I'm still struggling with, and I'm sure it's entirely my fault, Mr Hobbs, is what you say they could have done if they didn't go by the contempt route. Because you say it's not our case that they're forced, if they're going to accuse you of a deliberate breach, let's say that that's what they're accusing you of.
Yes.
Obviously what they're doing. They're accusing you of a deliberate breach of contract or a breach of the order. Breach of the order, and therefore you say it's inappropriate to go down the 40 route instead of the 81 route, but you issue a positive submission that you have got no choice but to go down the 81 route.
Yes, they
I'm still confused as to what your case is, as to how you would go down the 40 route and still maintain the protections under the 81 route, which
Right.
is what you seem to be saying.
Right. So, there are plenty of cases in which that which could have been brought as a committal by virtue of contempt, that is the breach, are not brought in that way. They are brought, and that they could have been brought here by means of a fresh action for a breach of contract, a fresh action for trademark infringement, a declaration of trademark infringement, a declaration of breach of contract, and they could have sought a ruling for guidance on interpretation of all the kinds which your lordships are the court is much more familiar with than I am, where people say, is X, Y, Z within the scope of A, B, C in the order? What is the meaning?
In all of those earlier examples you gave, so fresh action for breach, etc., the standard of proof and the burden of proof would have still been civil.
Yes.
There would have been no right to silence, correct?
I'm agreeing.
And so they would be accusing you of a breach of an order or breach of contract. And it comes to the same thing, doesn't it, in that situation?
No, I have repeatedly said in my submissions that I've called it the going the whole hog. If you are going to ask for an adjudication with all the raised judicata, issue estoppels and all the rest of it that's going to go with it, and the adjudication you want is that it's a breach of a court order, then my submission to this court is that you have standards you must meet. And they are standards for the protection of the defendant, and you're not doing the defendant a favour when you say, oh, it's a simplified...
So it does come back to the fact that the exclusive procedure is Part 81.
Yeah.
For an accusation
Of breach.
of breach.
Yeah.
But the declaratory relief provisions, as we know because we've examined them exhaustively, and my Lord's judgment in the Tesla case did too, and I showed you the material from Lord Justice Lewis's book, and I was clear to say to you that there are, if I say residual or exceptional or whatever, there is a residual or exceptional power which the court will exercise when granting declaratory relief, even though, on my case, it collides with the need not to cross over into the criminal law, the unlawfulness associated with the criminal law. Now, Lord Justice Lewis says in his book, it's not, the law is not clear, but basically he comes to the view on the authorities that he mentions and analyses, that it's an exceptional jurisdiction. Now, the kind of exceptional jurisdiction which comes up, which you can see in the case law, is where the doctors at Great Ormond Street are engaged in the question of whether they can or can't withdraw treatment, whether the point has been reached at which the decision, who takes the decision. Those cases are dealt with, again, the court will know better than me, those cases are dealt with by way of rapid declaratory relief. And you can foresee, for example, if legislation currently being discussed in Parliament about suicide and assisted suicide and so on and so forth, you can see more cases of that kind. So the court will never say never, never say never in relation to 40.20. But I stressed, I repeated myself, wrongly perhaps to repeat myself, the policy of the law is not to cross over via declaratory relief onto the what I call the collision with the unlawful conduct adjudication. And so the point has been put to me more than once. I say that's what they're doing. In fact, what else are they doing? A declaration that 55 instances amounted to breach of a court order. What else are they doing except saying they want an adjudication that I have violated the court order? and so on and so forth. That's what they're doing. And I've been protesting at all stages that this is not apt. I've been making the point that they should reframe their relief. Mr Justice Mead thought that they would be doing it. He assumed that they would reframe their relief. I've indicated ways in which their relief could be reframed, and it happens quite regularly that properly focused relief directed to interpretation as such, and applicability of the words as interpreted, it can be done and is often done in the courts. It's just that they've gone the whole hog. They set the parameters. And that's why I say, based on my argument for the requirement for a legal standard, where else do you look, I would say rhetorically, than the legal standard which is mandated by Article 6 of the ECHR via CPR 81.
Even though there's no risk to your clients whatsoever of sequestration or anybody being imprisoned,
there is a
anybody
risk, my
being
lady.
fined,
My lady, there is a risk.
not on the basis of what's been found by the court here.
Well,
It wouldn't be admissible in the criminal proceedings for a start.
well,
The only thing that would be admissible is any ruling as to what the scope, what the order actually means, and that would be the issue estoppel.
but the whole of the premise against me is that it's already a particular act, let it be an act of X on a particular day, is an act which is being found intrinsically by its own very nature to be a breach of the order.
You'd still
As
have
far-
to prove that you've done it again.
Yes, let it be assumed that by accident it's happened again. Let it be assumed, as I understand it, that would not be inadmissible in the committal proceedings, that they would give evidence about it and it would be adduced as a breach having occurred, the repetition of which is sought to be punished.
And if it happened by accident, you'd have a defence under 4B.
But that's a characteristic, with respect, my lady, of the particular drafting of this order. It's not a characteristic of the procedure as such.
I'm just at the moment trying to work out what the jeopardy is that you say that you're in.
I don't need to be in jeopardy beyond. First of all, I would
Theoretical one.
no. First of all, I would say I don't need to be in jeopardy at all. It's not an appropriate procedure to go the whole hog, and the case that proves it's not necessary to be in jeopardy at all, in any real jeopardy, is the Amstrad case, where the Court of Appeal said we're not granting this relief, even though there is no real likelihood that we can see that you will be prosecuted. There is no imminent prospect, but if you were, we don't want the criminal court to have this judgment to deal with. They said that explicitly. And anyway, I am in jeopardy. Otherwise, what is the point of all this? What is it that they want to establish by means of res judicata and issue estoppel? I can't understand why it is said that they are able to claim these declarations that go the whole hog, and yet they don't hurt me or harm me or affect my position in any way. I'm not able to see it. I'm sorry.
Well, if an order simply replicates a contractual term and prohibits you from acting in breach of that contractual term, what's the difference between a declaration that something is in breach of the contractual term that is embodied in the order and a declaration that it's a breach of the order? Either of those will bind you, and if you do it again,
Yes.
you'll be found to be in
Yes.
contemptuous breach.
Yes. In the breach of the order. No, in the example that my lord puts to me, the difference and the distinction is wafer thin, but it's not wafer thin in this case. Let me say that first of all.
But if it's wafer thin, or I'd say non-existent in any case, it undermines the premise of your argument.
And the reason I said it's wafer thin in the example you give me is because the adjudication that is asked for is a breach, and in circumstances where it's not breach of the contract, it's breach of the court order, that is what turns it into something which brings into play all the considerations associated with breach. as my lady has put to me, that in a full-fledged breach application under CPR 81, you'd have all the issues about, we don't use, I think, the language contumacious anymore, but
But that's not about breach, that's about contempt.
and that's what breach of a court order is.
If it's deliberate, yeah.
You can breach the court order without being contempt. If it's,
Well,
it's not deliberate.
When the allegation against you is, as it is here, I want a declaration that you're in breach, and the reason I want it is because I want it to have it in my back pocket so that if and when I want to use it, I can mount contempt proceedings. That, in my submission, is a clear example of the point I'm putting. Now, my Lord is testing, I think, the periphery of around that point and where it goes. I am still maintaining that there is a valid legal distinction between a claim for a declaration that a contract has been breached and a claim that someone has breached a court order. And that's because breach of a court order has extra dimensions to it over and above the kernel, so the kernel and the husk. The kernel may be breach of contract, that may be the fact that the central DNA of the injunction, but if the accusation is breach of an injunction, I say that is juridically to be analysed and understood for what it is.
But you get many situations in which a party comes to court and says, court, you know that order you made against the defendant? They've not complied with it.
Yes.
So I therefore need further and better relief. Because the first relief wasn't enough to deal with it.
Yes.
Now the court can determine, and if necessary, can put in the recital to the order, and upon the defendant having failed to comply, I therefore order the following. And they can plainly do that without having to require the claimant to go through a Part 81 procedure in relation to the breach. It may be very often that there isn't time to do that.
Yes, yes. Now, I'm very familiar with the proposition that you can ask for supplementary provisions to reinforce the operation and effect of an existing order. I'm very familiar with that. But then there have been other cases in the early days of what we used to call the Moravian injunction, in which there was this whole question of whether you can compel the defendant who'd received the order against him or her to come to court and face cross-examination and submit to cross-examination. And if I remember correctly, there was a period during which that was it a case called Bayer against Winter? I think that
that was Anton Pillar order.
That's again.
But I believe that the point was the same. If the allegation is non-compliance by failing to provide information, the question is then whether you can compel the defendant to come to court and face cross-examination and provide the information. And the reason for the concern is that the process of compelling the information out of the defendant is thereby compelling him into a situation in which he may be almost inexorably putting himself in breach.
But everyone has a privilege against self-incrimination.
Indeed they do.
In any civil proceedings.
Indeed they do. But it would at least be clear at the outset.
And it would apply in these proceedings if your clients considered anything they said would incriminate them in subsequent criminal proceedings or indeed contempt proceedings, then they would not be obliged to answer.
Yes, I understand that, and I understand that, if you forgive me for saying so, at a theoretical level. The reality is, here I am, I've got all this paper, and I just cannot ignore that the wheels are grinding under CPR 4020. I can't ignore it. I can't ignore it in circumstances where there's case law, and I'm thinking in particular of the Cipriani judgment in which it's been done before, albeit without opposition. I can't ignore it. I'm placed actually in an invidious position. Now, of course, I could blow up the whole establishment and say it's contempt or nothing, and I'm walking away, and I'm not going to speak to you, and I'm not coming to court, and I'm not going to participate. And what would happen? Struck out. There'd be further orders, we'd be in the type of situation I've just been discussing here. So, if you don't mind me saying so, It's not that in theoretical terms I couldn't have said, right, I'm treating you as bringing a committal proceeding by another name. It just doesn't enable me to proceed in a meaningful way in civil litigation in this country in a dispute like this. And this is a business relationship, like it or not, I mean us, like it or not, that's been in place like this since the end of World War I, when these two companies were split up as a result of enemy property orders in the United States.
No, that's not correct. It's a matter of history. There is a common origin, but that's not the reason for the split, by contrast with some other well-known cases.
My Lord, I beg to differ. There's a judgment of Mr Justice Newgee in which we went through all of this. There was an order made in 1918, and then my client's business in the US.
Well, it's not reflected in any of the judgments we've got before.
No, you haven't got that one. I mean, that was a question of what was the governing law of the contract, and Mr Justice Newgee went through that in some detail.
All right, I stand corrected.
So,
but it doesn't make any
difference. It doesn't make any particular difference, except let me call it a long time. We're here. I don't think either of us want to be here beyond a certain point. So you'll forgive me, my lord, if I say yes theoretically, but no, not practically. Right, so for better or worse, I've launched that ship, and there are ways in which they could have reformulated, but they chose not to. Ground 2 is the targeting point. I call it the targeting point in that way and at this point addressing paragraphs 2 and 3, because it's a threshold requirement for 2 and 3 that there should be targeting, treating targeting as a shorthand expression, which is all it ever has been, for participation in activities in the United Kingdom. Now, I have shown you the grounds of appeal which touch and concern and go round this point. As I understood my learned friend here this morning, he was saying that the judge should be taken to have found that there was use by my clients in the course of trade in relation to goods and services in the United Kingdom, and that they were MSD goods and services. That's what I heard him say this morning. The judge hasn't said that anywhere in his judgment, despite the arguments that we strenuously made to him about the need for there to be use in the course of trade in relation to goods or services in the United Kingdom, despite the point that I made to you that the judgment of Mr. Justice Norris explicitly made findings on the premise that there was this suite of websites. And of course, if you have a suite of websites, it produces a unification that doesn't exist if you have disparate websites or discrete websites. And it was only on that premise that the judge, when the matter was remitted to him, because his judgment on trademark infringement was set aside in the Court of Appeal first time round, it's only when the matter was remitted to him that the judge then spelled out the basis on which the liability was found, and it was used by my clients in relation to MSD goods and services via the material link concept. The judge surely could not have confronted the issue now without referring to the unchallenged evidence we had given about how everything was structurally different. To my side, it's inconceivable that the case could be dealt with now without that point being uppermost in the judge's mind. And moreover, with that point uppermost in the judge's mind, there must surely have been, but there aren't, findings on paragraph 3 that there was use by my clients in relation to goods or services in the course of trade in the United Kingdom. And I can't see it in the judgment. So there's a missing, I would say, finding, and there's a missing essential premise. All we can do in a case like this, where we have permission to appeal, is what we had to do the first time round when we appealed to the Court of Appeal in 2017. You can't expect, I can't expect my Court of Appeal to sit here and go through it all as if you're sitting as judges at first instance. It's not possible. I have to pursue the argument I can and substantiate it as best I can without expecting you to do the whole exercise over again, because that's not the way it works. And we've done what we can with the material, made the submissions we've made, and I stand on those 2 points. No mention of the change of circumstances, which was central to Sir Alistair Norris's judgment, and no findings of use in the course of trade in relation to MSD goods or services. There are no other goods or services capable of being said to be in the course of trade in the United Kingdom. And without that, you don't have a basis for a paragraph 3 finding. You simply don't have it. When I spent time going back to that case in the CJEU, I forget the name of it, the one about the customs.
Rio Glass.
Say again, my lord.
Rio Glass.
Thank you, yes, Rio Glass. I was stating what I understand to be a completely unassailable point, which is that it's in the very nature of a trademark that the activity which infringes should involve marketing, and marketing within the territory, even if the goods aren't there yet, marketing within the territory. And although those were customs cases, not all of them, those were customs cases, there's no difference between goods or services being in bond in customs and being in a far-flung country. They might as well be in Timbuktu. In other words, being in bond is the same as being in Timbuktu for these purposes. You still need to have evidence and findings of marketing of goods or services within the jurisdiction, and there isn't any. Now, wrapped up in the question of whether there is or there isn't marketing is this question of pop-ups. Now, I got up to correct my learned friend. It didn't stop him. He continued to use the expression fig leaf. It came back again in the transcript. It isn't a fig leaf. And what's more, the importance of the pop-ups is itself discernible from the form of order that was made by Sir Alistair Norris. Just to remind you again, if I may, behind tab 10, in particular, it's page 227. In paragraph B. Now, leave aside, because I'm not addressing it at this precise moment, leave aside what is meant by a UK-specific website and assume it means something which is simply, solely and exclusively directed at the UK. That's an MSD-specific website. Assume that. the proviso recognises and accepts that a pop-up is efficacious for the purpose of making it clear to the internet user on their journey that they are leaving and going to another website. It's actually in another jurisdiction. Now, how is it, this is a rhetorical question, how is it that in what is a very clear case of linking, I mean that's as strong as you can get on linking, how is it that that proviso gives you wording which is efficacious for the purpose of satisfying an exclusion which takes you outside the scope of 2 and 3? The very fact that the court prescribed this wording and did so after argument as to what the wording should be is testament to the fact that in principle a pop-up is efficacious, and one in that wording is certainly efficacious.
Well, it may or may not be, it depends on the facts.
But in the facts here, my lady, the exemption is not linked to the circumstances other than the fact that there is a link from a specific website to a Merck website. In other words, the operation of this provision in which this pop-up wording is efficacious is not elaborated by reference to surrounding circumstances. It's linked, it's related to the existence of it occurring automatically. If my lady were to say to me, yes, but when they've gone through the pop-up and they've landed and they're doing the Amazon journey, then in those circumstances, there might be something there that, having gone through that nonetheless has the effect, once you've gone through immigration control, so to speak metaphorically, that has that effect, that could be then pointed to. And I accept that there may be something above and beyond through that, but I'm trying to drop anchor on the point that this is, in principle, efficacious, not to be dismissed as a fig leaf, which the Court of Appeals certainly didn't dismiss as a fig leaf, and that the wording is determined, it was settled by the judge after hearing rival submissions. Now, it's not a contradictory message. It's actually saying to you, you've now gone from here to there. And that takes you back to the point that's always made. Accessibility of a website is not enough to constitute use in the course of trade within the jurisdiction, etc., or targeting. And why isn't it? Because the internet cannot function on the basis that people can't, if they choose to do so, make a journey to a website in another country, and if that's what they know they're arriving at and what they're doing, that should break the link with the UK whence they came.
But if it's intended that they should go there, if it's always been planned that they should go there, that there's no basis for the link being there other than to direct them to the website, then you're in different territory, and that's what's happened here.
With respect, my lady, that is exactly the background against which this order was made. That was the very thing that the judge was dealing with. The very thing. It was because the whole suite of sites was set up, which MSD websites were in large measure acting as a portal to the US side, that the judge dealt with it. This is the solution to that. And if we broaden it slightly, can we see how some of the arguments will take you? It's reaching the point in some of my learned friends' submissions as I was listening to them, that my clients can't have anything on their website when people land up on it that is of interest or relevance or concern to people in the United Kingdom. But that's extravagant. That's really extravagant. It would be extravagant even apart from the fact that I have a contractual arrangement which fully entitles my client to have that website and to actually put what they like on it, without let or hindrance from these claimants. I have a right under that contract in North America to have a website and to have my chosen content on it. What I don't have the right to do is to go further and then violate the provisions of clauses 2 and 3 and the law that stands behind them. This is going to turn into a nitpicking exercise about information of interest, like the safety data sheets and so on and so forth, because there's information there of interest to people in the United Kingdom. And by the way, that would be information of interest to everybody for every territory of which there was an SDS sheet. That's information that must be, under this injunction, made inaccessible to people in the United Kingdom.
It isn't that it's of interest to the United Kingdom. It's the fact that it's of interest only to people in the United Kingdom.
It's, as I understood the evidence when Mr Hollingworth was going through it, and as I remembered it before, it's a whole collection of SDS sheets, of which one is the United Kingdom.
Yes, but that one sheet is of interest only to people in the United Kingdom.
It's of interest to people that wish to do business in the United Kingdom in things that would be within the scope of the SDS regime. My Lord Justice Arnold pointed out that there are, they're not identical, but there are parallel provisions which give rise to these sheets and the information contained in them, the need to provide them. It's a regulatory thing. So the answer to my question, to your Lordship's question, is that if there is someone with a regulatory interest in the United Kingdom, then in those circumstances, what the SDS sheet shows, it could easily be of significance to them. And the SDS is also applicable to things which are in transit to and from the United Kingdom. So it's not confined to things in the United Kingdom. It's basically like a sort of a transportation certificate, so that I won't say hazardous waste, but it's the kind of metaphor that springs to mind. Now, are we really going to say that the accessibility of an SDS sheet on that massive website in the United States to someone that's come through a pop-up involves use of a mark in the course of trade in the United Kingdom in relation to goods or services? This is extravagant. And I move to the question of the interpretation of 4B. You have my submissions. It's not, as it could have been, defined in a way which has a top-level domain which is, call it UK specific. It's the content of the website which will or won't make it UK specific. Now, is it envisaging, in all the circumstances of this case, is it envisaging that the website in question should be 100% content specific to the UK? Or is it actually, to adopt a more real and commercial perspective on it, is it envisaging a website in which there is information which is, shall I call it, multivalent, that is to say, not confined to the United Kingdom, but which is of interest in, amongst other places, the United Kingdom? Is that not, I'm submitting that it is, that is sufficient, that is sufficiently linked to the UK to be UK specific. It does not have to be singularly, solely and exclusively UK specific, which is not something which is actually technically or commercially attainable. And by the way, what would the position be if it turns out that you had such a thing that you thought was UK specific, but in fact it was being visited, as so many sites are, by people from France, Germany, Portugal, you name it? What's the position then? The truth of the matter is that a website is by its nature accessible from here and there and other places. It has a multivalency in terms of the territory to which it can be said to relate. And that we submit that the interpretation placed on this clause by the learned judge was unduly restrictive, not commercially realistic, and that it wasn't necessary to adopt the position that he did, and it wouldn't be right to adhere to that position. But you have my submissions. On the email addresses, my learned friend was addressing you on this a little while ago, and as he got more and more to the end of showing you the passages which preceded it in the judgments, I was seeing and hearing, not that it was for the first time, but I was seeing and hearing how the judge was concerned not to have territorial overreach, how he was actually concerned to protect the position of employees working as such within the organisation outside the United Kingdom. And his main requirements were that they should be working for the organisation outside the United Kingdom, they should be employees, and that they should be using domain names with that suffix. Now, my point remains the same, and you heard a lot of rhetoric about, oh, this is the thin end of a Trojan horse, let them do this and it will all proliferate everywhere and so on. My point is actually simple, plain and unvarnished to the following effect. Referring to an employee by the role that they perform is within the scope of this order, as this exception I should say, in circumstances where they're located outside the United Kingdom and this is the suffix that they're using.
The role they perform, is there an example of any of the email addresses in question where it is role specific? So let's just say personnel manager at Merck.com.
I see.
I don't believe there are any, are there?
I don't know, and as you know, I've had a division of labour, so I should carry on slightly and then wait for a yellow note if there can be one from behind on this. I haven't got it all in my head, my lord.
They're functions, not roles.
Their functions, not roles. I'm slightly concerned that that's an artificial distinction in the sense that one blends with the other. As I gave it in oral submissions yesterday, I gave the example of clerks at OEC Law, or my clerks on Team B at OEC Law, or my named clerks. There's a cluster of people sitting there, and the functions they're performing are the functions of barristers' clerks. If there is one, it'll be found behind me, but at the moment I'm not.
Okay, if you find my terminology unambiguous, let me try and be unambiguous. Job title. So do we have any examples of email addresses in the form job title at Merck.com?
Well, I don't know whether we do. I'll be told if we have, but the reason we wouldn't have is because we are responding to specific allegations linked to specific email addresses in circumstances where we're not producing a whole portfolio of them. I mean, we've got hundreds of thousands of employees in the rest of the world. And I mean, I wouldn't begin to know how many there might be that perform that role. But I think, if I may, I would politely say that that is demonstrative of the force of my point. Because if they are, and if the court was minded to think that they are within the scope of this exception, it would demonstrate that the exception is not limited to circumstances in which they use the name Joe Bloggs at Merck.com.
Well, no, with respect, it establishes precisely the opposite. It shows that there isn't a need for it to extend to job title at Merck.com. The real concern is Joe Bloggs at Merck.com or Fred Smith or some other name.
I would beg to submit that actually the concern is that people who are doing their jobs as employees should be contactable in a way which is material and relevant to the role they're performing, given that you must recognise that in any organisation anywhere, but let alone one of this size, personnel move around, they change, and if you want to make sure that it's getting to someone at the correct function, performing the correct function, you don't link it to the name of an individual who might not be there in 6 months' time or a year.
That's the point against you.
Yes,
I,
precisely.
if you don't mind, I treat it as a point in my favour.
Right. Okay.
I mean, I mean, commercial utility. Where do we go next? That they must use their whole name. So it can't be Hobbs@Merck.com. It's got to be Jeffrey Hobbs@Merck.com. I mean, where does it go next? It can't be your initials. It has to be your full Christian name. I just don't know where this goes next. Even if you individualise it down to, if you like, the specific DNA and fingerprints of an individual human being, I mean, that really is not necessary. It really isn't necessary. It's not commercial. It's not sensible. There must be some latitude. I've argued for a certain degree of latitude. If the court's not with me, the court's not with me. But there must be some latitude. Surely, I say to myself rhetorically.
But aren't most employees going to have an email address?
They may have more than one.
Yes.
Well, they may. But what is the difficulty with the interpretation that this is relating to those email addresses? If they have more than one, then they have more than...
Yes, when I said more than one, my experience has been that it's very common for people who work on the same team to have a team email address for their team and their own individual email addresses
Yes.
within all that. It's very common. And
you may have... People may be able to contact you through your clerk's email address.
Yeah.
But you will have an email address.
I do.
And it seems to me that is the one that is referred to in this paragraph.
Well, where I'm differing is this. I have a team of clerks. I haven't counted them recently, but there might be 5 of them on the team that deals with me, and they all have individual names. But they are clerks, Team B at OEC
And each
Law
of those
Doc-
clerks will also have their own email address.
And they will. But the point I'm making is that in being my clerks, they don't require that my email address should be used for communications with them in their role as employees of chambers acting as my clerks. Team B is a sufficient nomenclature to identify a cluster of people, all of whom would be, within the parameters of this, employees using their email addresses. No, but we're reaching the point where there's either no clustering of these employees under an email address, or there can be. And if there can be, the question then is whether the case for which I've argued is acceptable. But if there's no clustering and they've all got to be individual head count one by one, well then that's what the judge said, and then you won't accept my submissions. Inadvertent error. I'm not insensitive to the remarks which passed between bench and bar when my learned friend was addressing the court just now on this. But it's a composite expression. The word inadvertent is not uncouplable from the concept of error. And on the wording...
Well, just on that, I wonder about that, because it's a little odd, isn't it? Because I remember at an early stage of reading into this case, I got it into my head that the relevant words in the order were inadvertent error. Then I looked again at the order and reminded myself that actually that's not how the clause starts at all. It ends with those words,
Yes,
but that's not how it starts.
I know. But
So,
Inadvertent.
so we start, as my lady was pointing out, with the words inadvertently to act in breach.
Indeed.
Then you get the concept of error being introduced.
Yes.
And finally, inadvertent error.
Yes.
But the starting point is inadvertently to act in breach.
But that's only your starting point. And the overarching requirement for this exclusion is that there's an inadvertent error which has been either rectified or not rectified within the 7-day period. Now, just pause for a second. I can put the 7-day period on one side because the judge said that in every case in which this has been invoked, the 7-day period was satisfied. Now, I understand perfectly well that it starts in the first sentence with those words, but it ends, and that's your conclusion. That's the thrust of this paragraph. That there has been an inadvertent error of which the defendant has become aware, and the two ways in which they have become aware of it are either by writing notification or otherwise, meaning becoming aware of it in the sense of conscious of it. But it's all about inadvertent error. And I understand that the opening words of it refer to breach. I understand that perfectly well. But the point, and remember, this was drafted by agreement between the parties, so we're all to blame for the fact that there is this lack of clarity, if there is a lack of clarity about it. In fact, I started the ball rolling, so I suppose I should be wearing sackcloth and ashes, not for the first time. But anyway, the thrust of it is an inadvertent error. The missing ingredient is cognizance, because it's the cognizance that is required to trigger the cure. Now, if you don't have cognizance that which you have done, brackets, classifiable as a breach of whatever it is, 2 or 3, if you don't have cognizance of that, the question then is it an error of which you are not cognizant? And I say again with respect, it's a composite expression, inadvertent error.
Does the cognizance have to be of the act or the cognizance of the fact that it's an error?
It's a realisation you've made a mistake.
So you say cognizance of an error.
Error? I'm equating error with mistake.
Yes, all right. Well, that error does usually mean mistake, but you may know that you have done whatever it is, but you don't yet know it's a mistake. You then find out it's a mistake and you act on it. Yes?
Yes.
That's your case.
You put your car keys in the fridge, you didn't mean to do that, and then you suddenly realise that's what you've done. Either somebody tells you, or you are suddenly made aware of it when someone says, where are the car keys?
Well, that's eliding the two with respect, because then you're not cognizant of the fact you put them in the fridge in the first place. So you're neither cognizant of the act nor of the error.
But that's my case. That's my case. That's what inadvertent error as a composite expression entails.
Well, then it can't cover a situation where you deliberately do the act, but you don't realise that it's a breach of the order.
There were two negatives there.
It can't.
I don't deliberately, or I do deliberately.
You do deliberately. It cannot cover a situation on that last answer to the question where you deliberately do something in the honest but mistaken belief that it's allowed, and it then transpires that it's a breach of the order.
On my case, the word deliberately has extra connotations which are not necessary for the analysis. On my case, a volitional act, which I take to be something that the actor decided to do, a volitional act can be a qualifying act and come within the scope of inadvertent error depending upon the conception or mindset of the person who actually did that act. To add the word deliberate...
That's the difficulty, because the volitional element means it's not inadvertent.
No, but it can be. I can do things. I come back to the example I gave of the counterfeit goods. The injunction says don't trade in goods which bear the mark squiffo. And the defendant, who's a trader, gets another stock of container load of squiffo goods and distributes them, believing they're genuine goods, but it actually turns out that they're such good counterfeits that you can't tell them apart unless you put them under some form of micro-reading device. That's a 100% volitional act, but it's an incognizant error relative to the order that will have been breached. And it will have been inadvertent when the defendant comes to court and says, I never intended to do anything other than deal in the genuine goods. There aren't neat dividing lines on this, and that's why I metaphorized it to the proposition that in the end it will become a question for the jury, and of course I'm metaphorizing there, as to whether, on the evidence that's available and presented, it was categorizable as an inadvertent error.
Well, you're equating the word inadvertent with unintentional.
I didn't in the example I just gave of the counterfeit goods man.
I think you did.
Did I?
Mm.
I intended to deal in genuine goods. The trader intends to deal in genuine goods and thinks that's what they are. That's intentional.
It's not an intentional breach of the order.
But that's...
It's a deliberate, it's a volitional act, but it's not an intentional breach of the order, you say.
Well, I'd say it's an inadvertent error, which is the language I'm focusing on.
Yeah.
Right. There's a limit to how many times I can say the same thing in different ways.
Indeed there is, Mr.
There is. Now, don't agree with me, my lord. Right. I think you've got the gist, the substance, and the full width of my submissions, and I commend those submissions to your lordships, to the court's tender care and mercy. Right. There is a point, and I hope it's not going to be necessary to go through the detail, but if it is, I'll have to. There were 5 instances that I counted specifically in which the judge decided the paragraph H defence on the burden of proof. And I can do it in 2 ways. I can
Just give us the list.
Do you mind? Thank you. Right. On row K, paragraph 304 of his judgment is explicitly that, failed to discharge. The same is row L, paragraph 312. Row S, 383. Row AA, 442 paragraph. And row DD, paragraph 460. Now those were the clear ones. There are others where the language of the judgment is kind of like open to interpretation, but I've chosen those as clear examples.
Could you please give me the row K reference again?
304.
Thank you.
I think it's 304. Do you mind? My writing is poor.
No, don't worry.
It's
It's just
either
I didn't
304
jot it down when you gave us the list. It was my
It's either 304 or 306. I can't read my own writing because I did it in a hurry. Was it 304?
Yeah.
He says it specifically, doesn't it? Yeah, it's specifically 304. Right. Now, on the form of order, yes, of course I could have claimed for a counterclaim for declarations of no breach, I suppose, if I'd wanted to accept the proposition which I was spending all my time arguing against, which is the question of breach, no breach, is raising issues which are beyond the contours of CPR 40.20. But that
Did you
isn't
not
my...
have made the application in the alternative without prejudice to your primary case?
Do you mind if I say theoretically I could, but as a matter of practical reality it wouldn't work? I've got a simple point. The other side put forward a list of breaches, and the judge, in his judgment, I forget the number. Is it 318? What number is that paragraph? There's a list that the judge produces, the table before the final portion of his judgment.
513.
513, his summary.
Yep.
Right. Now, after what we've been through, and certainly if this had been a contempt proceeding, sorry to take the analogy again, but if this had been a contempt proceeding, the judgment of the court would have been counts 1 to 7 upheld and counts 8 to 24 not upheld. In other words, the completeness of the result, which should have been, in my submission, reflected in the order of the court, required it to be comprehensive, not myopic. The form of order that we put forward simply did the same as the other side's order, which the judge accepted, except that their order only identified by reference to the annex the ones on which they had succeeded. And what we did was say, please put in an annex which includes the ones that they didn't succeed on and say that they didn't succeed. That's all we asked to be done.
You got it in the judgment.
Well, then I could say they got it in the judgment. The point being that there would have been an adjudication in the form of a court order, which is after all solemnises the judgment. The solemnisation of the judgment, we say, should have been complete. I did get it in the order, but in circumstances where, if you remember those words of Mr Justice Neuberger, justice to the claimant, justice to the defendant, etc., should or shouldn't grant, remember those contours that come from his lordship's observations, that carries through, I would say, to the relief stage. Why not? And if it carries through to the relief stage, you are actually stating, I decided not to. For reasons that seem good to me, I decided not to. It's a very lopsided form of order to choose only the ones on which the claimant succeeded and not include the ones on which the claimant failed and the defendant succeeded, in circumstances where every single one of them was binary on the way it was argued and presented. And the judge gave me permission to appeal on that. Now, unless your lordships and my lady beg me to make further submissions, which I think may not be about to happen, I think I'll sit down and shut up.
Very good. Thank you all for your submissions and those behind you. We will be reserving our judgments. They will be handed down in the usual way, that is to say digitally with no attendance required. As you all know, you will get a draft or drafts under embargo, which must be strictly observed, and you know all about that, for correction of typographical errors and basic mistakes of that kind, but not to re-argue the case, and also to try and agree a consequential order, which I know the history of this case suggests is not always straightforward, but we hope you will nevertheless be able to do so. If perchance you're not able to agree the consequential order, then short written submissions, please. Thank you again.